who's on the meeting. Can't see your faces, but you know, everyone I think is getting used to Zoom and all of its fun learning curves. And so, yes, appreciate the time, everyone. So my name is Tyler Priest. I am the VP of Business Development for Greenleaf Payroll and Business Solutions. So we specialize in everything from hiring, recruiting, electronic onboarding, to actual hands-on HR support for businesses from 1 employee to 1,000 employees. What we'll kind of go over today, and we also are able to help high-risk industries, one being cannabis and some of the pitfalls of that type of business vertical. But what we'll talk about today, since I have a special guest with me, I've known him for, David, how long have I known you for? Probably, what, 7, 8 years?
About that, yes.
Something around there? Oh, man, just makes me feel old talking like that. So I've known David Hall for a long time. He is one of the partners at Carlsbad Law Group. And so really what we'll kind of go over today, and I would love engagement from everyone and want to have this be not just a death by PowerPoint, but what we'll go over is just some of the pitfalls when it comes to labor law compliance, especially in 2020, some of the biggest hot buttons that we see. David will be able to share, myself, some just examples of where a business can just overlook something and what that can mean. So we'll walk through some of that, and then some of the details of what's kind of evolving in that regard. So things on independent contractor and some of the recent changes that have occurred there. But during the presentation, would love to have on that Zoom group chat questions that come in on anything we discuss, or specific questions for David and myself. If you would like us to elaborate on anything, definitely would love to have that kind of going throughout, and I'll monitor that chat box at that point. So let me share my screen with everyone.
Tyler, I did find the poll if we'd like to do that, or let me know that that's not necessary.
Yeah, if we want to. Yeah, if we want to do that, that would be great. And so hopefully everyone can see my screen. Deborah, if you can, I'm going to believe everybody else can.
Yes.
All right, great. So again, we'll start to dive in and break down some of just the common mistakes that we see happen when it comes to labor law, having employees, and things that impact businesses from just 1 employee all the way up to 1,000 employees, and just those pitfalls that can come about. And so, David, did you want to add anything? I mean, any other parts for your intro?
Yes. One of the things that we have in common is that we all do work in the People's Republic of California. So it's very important to understand that California deems all employers are out there trying to cheat and defraud and abuse employees. And you really have to start from that assumption to understand why these law applies and what the obligations are of the employer. So,
perfect. Yep. The burden of proof when it comes to human resources and having employees or employee allegations is on the employer at that point. So if you hear us at nausea talk about documentation and the importance of that, the People's Republic of California will be the best way of explaining that. So one of the biggest common mistakes, pitfalls, and there's a couple different, it can become a snowball issue at that point, but wage and hour, and the wage and hour division that oversees this part for employees. So timely payment, overtime, meal and rest periods, pay stubs, independent contractors, piece rates. So a lot of these things are going to be something in your policies, procedures. Your employee handbook is really where you're going to disclose how you're going to pay the employees that you're bringing on. So whether they're hourly, whether they're what's called non-exempt or exempt at that point, which we'll get into a little bit of that misclassifying and what that can entail. But overtime rules that you're following, what California sets out in regards to overtime. But one of the big ones that we'll walk through a couple examples as well is the meal and rest periods. The other part that we'll go into right now, and I'll show my screen in that regard, is actually dive into just an example of that. Let me just make sure I have my chat up real quick so I can see that come through.
And Tyler, can you put it
So
in?
this is actually,
Or
yeah,
will you put it in
what's that?
presentation mode or keep it in PowerPoint?
Yeah, I'm not sure. Let me see. Let me share a different screen then real quick to do that. Thank you, Deborah. All right.
Perfect.
Perfect. So in regards to this is, and one of the things that comes with wage and hour as well is going to be timely payment upon separation with an employee, which is something that we probably are familiar with here on this call, but you do have strict timelines in which you have to pay an employee on that last day. And so this is actually a real labor commissioner violation that came through. So this is what something, if not done in the correct timeline, what can end up entailing at that point. So with that, this is, and it's a little blurry, so I'll break it down for everybody on the call, but in this labor commissioner hearing, this was a final check was due to the employee of $3,500. So on their last day, they were due $3,500. And unfortunately, in this example, I've blacked out the name of the employer, but in this example, they did not give that in the time frame that they were supposed to. And so now this is where penalties begin to accrue at that point. So you'll see here a small amount of money for the penalties that coincide with not filing that, not giving that check upon that final termination. And so here's where it begins to get bigger and bigger at that point when it comes to wage and hour and that timely final check. If you have where that number right there, if you can't see it, it's $120,000. David, if you want to break down why that jumps like it jumps, I'll have you kind of chime in that regard. And then, I mean, so essentially this went without, this employee did not get that final pay, and it went the full distance of 30 days. And that's where that number came from. But David, if you want to talk a little bit more.
Sure. Under Labor Code 203, when an employee leaves employment, the employer has an obligation to pay all wages due. The time frame differs as to whether or not you fire an employee versus the employee resigns. If you fire an employee, all wages due are payable immediately. If an employee resigns, you have 72 hours to pay that employee, or if the employee gives more than 72 hours notice. So if they give a 2-week notice, their final paycheck is due on the last day that they work. The willful, which means you should have known but you chose not to, failure to make this pay subjects the employer to a penalty of 1 day's wage for every day you don't pay up to 30 days. So in this specific example, the Labor Commission determined that the daily wage of the employee was $4,000 a day. So when you multiply that by 30 days, that's how you get the $120,000 penalty. It was also interesting to note that the statute of limitations for this claim is 3 years. So you can actually have employees coming back years after they leave and say, I was short all wages due. Now, all wages due does not necessarily mean their last paycheck. If there's accrued vacation, that's considered part of wages due. If they've been misclassified, that's part of all wages due. If they haven't been, if there's been deductions, that's all wages due. So it's a lot broader than just the last paycheck. It's actually anything that you owe the employee in the form of wages. Failure to pay that, even if it's as little as $5, can give rise to this penalty.
Perfect. And also, this goes back to, again, I'll say it already, but the documentation piece. So when bringing on that employee in your employee handbook, what David had mentioned is any type of accrued vacation, any type of policy where it's an earned benefit to that employee, that is a factor of those wages. So that's where, if that's not paid properly at the end, then you can still see a penalty, even if you did pay them what was their typical per pay period or per day wage at that point. And so, and then in this example, the other compensation sector where essentially the penalty doubled was because this example that final check, when they did issue it, ended up bouncing. And so the total for this example was actually $243,953 after penalties and back wages that were due to that employee in this example. So this is another big one is meal and rest breaks. And being in California, we have strict timelines on when meal and rest breaks can be taken. And again, if they're not taken in the window that they're supposed to, if an 8-hour shift, they need to be taken between the 5th and 6th hour. They cannot go past the 6th hour. You can extend to that past the 5th to 6th hour if you have a actual meal break waiver in agreement with that employee or the employees in that position. And so, but if you do miss those time periods, or if an employee works through their lunch because they are trying to accomplish their task, which is great. One of the things to make a quick note, you know, we're talking a lot about compliance and the different penalties that can come about based upon the regulations and laws that have been set in place. But really building a great company culture begins to prevent compliance having to kick in and having to be very reactive. And so by setting that stage properly upon that first day of hire, where things are very clear and understood by that new employee that's being welcomed into the organization, can save a lot of hurt in the end. You know, and I see this happen. I've seen this with employers, of those employees that work through lunch, let that happen, don't document those things, and then that's the very thing that comes into question. For meal and rest breaks, David, what do you typically see besides that? What is the statute of limitations? When do you usually see these things get brought into a court situation?
I see rest violations of the rest periods all the time. That is a real favorite of plaintiffs' lawyers. So there's a critical difference between meal and rest periods when you keep documentation. Meal periods are 30-minute real periods, and there must be evidence of an employee clocking in and clocking out for the meal period. It must be tracked. Rest periods, you don't have to clock in and out because they're paid. The problem is that you would be fascinated by the number of people who never get meal periods and never get rest periods, but never complain about it until they hire a lawyer. And then all of a sudden it becomes a big deal. The penalty for missing a meal and rest period is 1 hour of extra pay per employee per day. One for a missed meal period, one for a missed rest period. The timing and the number of meal and rest periods is basically dependent on the number of hours that the employee works. So if an employee works 0 to 3 hours, 29 minutes, and 29 seconds, they get no, or 59 seconds, they get no break at all. If they work 3.5 hours up to 5 hours, 59 minutes, and 59 seconds, they get 1 rest period. At 6 hours, all the way up to 8.5 hours, they get 2 rest periods. And then every portion of 4 hours thereafter, they get an additional rest period. Meal period, from 0 to 4 hours, 59 minutes, and 59 seconds, there's no meal period. At 5 hours, you get 1 rest period. At 10 hours, you get 2 meal periods. At 15 hours, you get 3 meal periods. If an employee works more than 10 hours, they must receive 1 of their meal periods. They can waive 1, but they must get at least 1. And again, it must be clocked in and out. Now, the importance of clocking in and out and the importance of maintaining accurate time records is really where it gets interesting, because California law imposes a requirement on the employer to maintain these records. If you do not have an employee clocking in and out on a specific day, the law will presume that you did not give that employee a meal period or a meal period. Moreover, it is sufficient just for the employee to say, I never took a meal period that day, if there's no corresponding clocking in and clocking out. So what then happens is you have to recreate time if you're not can show that they actually did take a meal period, or you're not tracking the clocking in and clocking out. Rest periods normally, most employers that we see include a rest period policy in an employee handbook. As long as the rest period policy is consistent with California law, that's usually okay. The big mistake that happens all the time is, for whatever reason, and I don't know why this happens all the time, is for whatever reason the employee never signs the employee handbook or an acknowledgement of the employee handbook. That's always a big issue. So then what happens is they say they never got it. Now, the advantage, one thing that California does allow you to do is it does not require the employer to police the rest period. In other words, if there's a policy in place and there's a decision made for where it's offered to the employee to take a rest period and the employee chooses not to, the employer is off the hook for that rest period. So what that means is, if the employee comes in and says, I never took a rest period, it's not a question of whether or not the company had a policy and denied them the rest period. The question is, was there a policy in place, and did the employer do something to stop or interfere with that ability of the employee to take the rest period? So that's the discrepancy between the two. These types of claims, I can tell you, are tailor-made for class actions. Class action lawyers love these things. Plaintiffs' lawyers in general love these things because they just assume they are entitled to it. And it becomes a real record-keeping nightmare to defend these types of claims.
Yep, perfect. So this example, I mean, just to put it in perspective, because David is right, it does become a class action a lot of times. And so, and one employee can bring this up, and then from there, others can attach, and then that's where plaintiff attorneys on the employment side love when that does happen. So, you know, $15 per employee files a class action lawsuit. Business has 100 current and former employees over the past 4 years. 50 current and 50 former employees. Allegations that the company did not provide meal period, like David was discussing, in the proper time period, so lack of documentation. From there, that $15 per hour employee who worked 5 days per week would be entitled to $75 per week in missed meal periods. Allegation is that the company did not provide meal periods to any of its employees, no documentation to support that. Plaintiff is asking for $1.5 million in missed meal periods, $180,000 in waiting time penalties for the former employees that weren't paid those upon termination, $500,000 in PAGA penalties, and $200,000 in pay stub violations. David, can you speak to what PAGA penalties are?
Sure. PAGA is the Private Attorney General Act in California, and as far as I know, California is the only state in the union that has one of these. What PAGA is, it's a statute that allows a private employee to collect penalties that normally were available to the Labor Commissioner. And so what happens is, for example, if you fail to give accurate wage penalties, a private individual can bring a claim for $50 for the first violation and $100 for every violation thereunder. That's under one of the labor codes. There's a separate labor code involving with pay stub violations that only the Labor Commissioner could bring. And in that situation, I believe the penalty is $250 for the first violation and $1,000 for every violation thereafter. PAGA allows the employees to go into that second claim as well and actually get a double recovery. Now, the purpose of PAGA is to allow employees to collect these penalties on behalf of the Labor Commissioner, and actually as part of a PAGA award, 75% of those recovered penalties go up to the state. The employee who's bringing it is allowed to keep 25% for themselves. And all of these claims also allow for the recovery of attorney's fees in addition to the penalties. So not only, in this particular instance, not only are we looking at about $2.25 million in actual fees and penalties, there's probably another $300,000 or $400,000 in attorney's fees tacked onto it as well that the employer could potentially be liable. And that doesn't count amounts they pay their own attorneys to defend these claims.
Because traditionally in employment law, on the plaintiff side, they work on a contingency basis, whereas for defense for the employer, in something like this matter would be more on a billable hour and retainer fee structure. Is that right, David?
Normally, yes. There are a few, although it's rare, there are a few plaintiff's lawyers that will require some hourly rates for bringing claims, but for the most part, most of the plaintiff's lawyers bring these claims with the assumption that if they recover $1, they're going to get all of their attorney's fees. There was a local attorney in San Diego, I think, prevailed on a claim for about $1,200, and the court gave him $37,500 in attorney's fees for bringing that claim. So that's the double penalty when you're dealing with wage and hour claims.
Yep. Great. And so I'll go into, David had touched on this briefly, and this is something that can be even a clerical issue. This is actually one that I was able to be with David in this actually deposition where they went over all of these different things. And this was, and David, I know you're going to remember it, but pay stub violations. And so, and David had hinted at that being a part of the PAGA penalties, which is important in this costly error, is because on the PAGA penalties, this is where it becomes very, very expensive, because on inaccurate pay stubs, there's about 9 different things that should be on an employee's pay stub or wage statement when you're giving that and processing payroll for them, whether on a weekly, biweekly, or semi-monthly basis. And so in this example, it's using a grocery store. I'll actually speak to the specific scenario that I was able to witness with David for a company, a large company. They have past and present employees. In this case was actually 3,000 employees. They processed their payroll every single week, so payday was Friday. So 3,000 employees at 52 pay periods for the year, where essentially the issue or what was being brought into question was the business name and the actual IRS EIN number did not match the address. And so that caused the whole pay stub to then be inaccurate and be eligible for penalties and fines. And so David had mentioned the $250, but what happens is those 3,000 employees, that penalty is capped at $4,000 for them, but the PAGA penalties are uncapped at that point. So roughly it was north of $30 million in that penalty alone of just a simple pay stub not having the correct information on that top left-hand side, where it's supposed to have the correct business name and address being there and being accurate. And so, David, I know you remember that case in that scenario. Do you want to share anything else on that?
Yeah, the case I was involved with involved whether or not the employer put the correct address on their payroll statements. The company was located in California, but included an address that had a P.O. box in Georgia. And it turned out that the company had surrendered its license and its ability to practice in Georgia, and the post office box actually belonged to its payroll company that had been set up. So we dealt with the total number of current and former employees that we dealt with was about 6,000. The claimant issued added up when you did the penalties and when you did the number of paychecks. The expert in the case determined that the value of the penalties was about $17.5 million. And that went forward, and it got certified as a class. It went forward on the merits. And the question was whether or not it complied with California law as to whether a P.O. box belonging to somebody else that was used by a company in an area where they weren't licensed to practice or weren't licensed to conduct business was a violation of California law. And that was the big issue in the case.
Perfect. And so we'll switch gears a little bit. And if you have questions, again, I'll be monitoring the chat box. But What we'll talk about is still a hot button. Over the last couple of years, it's evolved, and even into this year, it's evolved with actually some, and especially the gig economy. So the tech industry has felt the repercussions of this change in California. Uber and Lyft are actually in the process of appealing this, but this is the independent contractor versus W-2 employee. So how will you classify that person that you're looking to bring into the business is absolutely vital, because from either you're classifying them correctly at the start or you're incorrectly classifying them, and now there's a potential risk inside the business that could come to a head at one point or another. So even the things that we talked about can be a part of something when you're incorrectly classifying an employee. And it's very important to understand the terms at which California defines an employee. California is always going to look through the lens that it should be and presumed to be an employee. And you can see that even on the slide under Labor Code 3357. But we'll talk about how it's evolved, what's going on today on that independent W-2 issue, because knowing David for as long as I have, being able to sit in on whether it was hearings of this being brought into question for a small two-man car washing business, and what that cost that car washing business on just one of their employees, which was over $30,000 in penalties for misclassifying them for just 9 months of work, all the way up to larger companies with 50, 70 employees that had classified certain personnel inside the business as 1099 when they should have been employee. And so, David, I'll walk you through and I'll control the slide so you can move through kind of the whole process of where we are today and where we started on that issue.
Right. So beginning of this year, AB 5 came into play, and this is what the new California statutes and regulations are for what is an employee, what is an independent contractor. And to understand it, we start with what was in the labor code prior to AB 5, and that is, what is an employee, what is an independent contractor? And the way it started with was, an employee is everybody who performs work for another except somebody who's an independent contractor. And the question that came up under the labor code was, if you are hiring somebody and having them do work for you in any capacity, they are presumed to be an employee. It is an affirmative defense to that claim that they're an independent contractor. Now, what the affirmative defense is, that you as the hirer of that person bear the burden to prove that they're an independent contractor. Then, so what does that mean? So we go to the next, Tyler, would you go to the next slide? So in 1989, the Supreme Court came out with what's called the Barela Test. You may have heard this as the 15-point IRS test, but this is what it is in California. And so really what Barela comes down to is whether or not the hirer has the ability to control the manner and the means of accomplishing the results desired. And then there are several factors. So the standard I use is, if you bring a plumber into your business to fix a leak, you have to look at that test. When you hire the plumber to show up, the plumber shows up on their schedule, not necessarily yours. The plumber is the one who brings their own tools. The plumber is the one who sets the payment. The plumber is the one who decides how to go. When they walk in, typically what you say is, the sink is clogged or the sink is drained. You don't tell the plumber, well, I think you need to use this type of wrench with this type of pipe, and I want to make sure it's, it's brass versus steel versus PVC. No, the plumber says, you say to the plumber, I have a problem, fix it. That's what the Barela test looks at and determine whether or not somebody is an employer or employer, or whether or not there's an independent contractor. So when we start going through this test, it's not necessarily clean, but it does count a bunch of factors. So we've actually had, in other presentations, we've actually had companies come in and say, Well, we initially hire all of our employees as independent contractors for the first 90 days. And then after 90 days, we hire them to be employees. The question I have is when you run into that situation is, how can you tell if they're an employer or independent contractor when they're effectively doing the same job and you're exercising the same control? One of the things you will not see on this list, and this is a mistake that I hear over and over and over again, is, well, they're an independent contractor because we issued them a 1099. The fact that you issue somebody as a 1099 does not establish they're an independent contractor. It's a consequence of being an independent contractor, but in and of itself, they are not. Another thing that I see all the time is people put in contracts, they say the parties agree they are an independent contractor, not an employee. That is a factor, but it is not dispositive. If you're treating somebody like an employee, even though you're calling them an independent contractor, California law is going to establish they are an employee. Part of the reason is, frankly, California wants to protect the employee because, of course, we know employers will always take advantage of them. But there's a more sinister reason for that is California wants the taxes associated with that employee and wants the workers' compensation benefits associated with that employee. So when we start evaluating whether or not people are employees, these are the types of tests that were traditionally done. A couple of years ago, I think Tyler, we can go to the next one, we came up with, the Supreme Court decided to completely change what an employee is. And this should be the Dynamex case. I'm sorry. Dynamex is now what kind of is the law, but not really. What Dynamex talked about is it adopted the ABC test. And it says what the hiring entity, i.e. the employer-employee, must, number one, establish that the worker is free of control and direction. Once again, they direct how the employee, what the ultimate role is, not how they go about doing it. B is the one that usually will trip a lot of people up and a lot of companies up, is it talks about the worker must perform work that is outside the usual course of business. So if business is in for example, in a dry cleaning business, and they charge for work that's being done for like tailoring, that's where it's in the usual course of their business. The argument is, it doesn't matter if they only work a couple of hours a week, but if it's outside the usual course of the business. And C, that the worker is customarily established in a trade. What this test did is it completely changed the landscape, because arguably under any of this test, even traditional businesses were subject to this. So for example, if a dentist brought in an anesthesiologist to help provide anesthesia for the patient, arguably it was within the same type of work. Or if somebody was a fulfillment company, for example, Amazon, and part of their business was to deliver product, because the delivery drivers are part of that business, they were considered in the ordinary course of business. So that's where we are now in 2018. Most recently today with AB5. Now, Tyler did mention this earlier. AB5, the Garcia test is, in light of AB5, basically resolved a lot of this. But in AB5, what they did is they put limitations on the ABC test, but they went back and reenacted the Barela test. So let me explain. AB5 started with the position of, we are presuming everybody who performs services for another. The general test will be the AB5 test, as we or excuse me, the ABC test that we talked about. However, we are going to put certain exceptions within the scope of AB5 that the Dynamex or ABC test won't apply, but it will be the old Barela test. So for example, one of the businesses that came in that talks about it involves licensed professionals. So if a doctor a licensed doctor is assisting another doctor, that is not under the ABC test, it is part of the Barela test. If you have qualified businesses, so if you have a business, two separate businesses, even though they're in the same line of work, if you can prove that the business is what they call a bona fide business, it is not subject to the ABC test, it is subject to the old Barela test. And there are several factors you have to have involved. So number one, you have to have a written contract between the two companies. You have to have separate office space. You have to have the companies having control on how much it's going to cost, how much it's going to charge. You need to have separate insurance policies. You need to have separate licensing. You need to have separate employees. You need to have separate payroll. You need to have all of these things have to separate so it really looks like a business. And what this is designed to do is designed to get around the people who go out and hire and form a new company with their spouse and say they're two separate companies, but really they're one and the same. Right now, the only exception that I'm aware of to the ABC test is trucking companies. There was a federal judge in San Diego who held the Federal Transportation Act superseded and replaced the ABC test for purposes of employees. That applies to trucking. It does not apply to all transportation. So for example, Lyft and
Uber,
these types of organizations are not exempt from that. They still have the ABC test that they have to worry about. And that's really where we are now. So this is going to open up a whole new area of litigation in this state.
Awesome. Thank you, David. So one of the things before I open up for question Q&A with David and myself is to talk also on just the impact that cannabis has had. So at Greenleaf, we work with that industry and even work with employees that are employed in retail and things like that. So even navigating that dynamic and then what that additional business, even with essentially allowed recreational use of marijuana in California. Medicinal has been longer than that, of course, but the biggest question that I see, and David, you can even chime in as well, but when it comes to cannabis, California is still firm, even up until this point with challenges and things like that, is still firm on a zero tolerance policy for drug use. Now, we see, and this is a individual business position at that point of if you want to essentially move away from that and not have that be where an employee is not hired because in from a drug screening or cannabis pop up in that regard to not disqualify a candidate in that regard. You can also, so you can take that type of stance if you'd like, just because it's all around us now. I mean, California and the shelter in place has deemed it an essential business. So the use of that is definitely not going away by the general population. So if you do not want to lose out on good employees, that possibly that's something that they do on the weekend and can still do their job, then you'll have to look at that documentation again on the front end, because when you do go to hire an individual, treatment among all need to be equal in that regard. You can look at doing different hiring policies and procedures when it comes to drug testing. You can do that for different positions. If you feel like a management level position that you hire, that's where we will do a drug testing and look at everything. But it is still something that in California, the employer still holds the right to, if a drug test essentially comes back with results that are not okay based upon the business's handbook and guidelines, then you can rescind that offer that you've given to that employee or that potential candidate at that point. So California is still in the corner of the employer of having that decision. They still feel that that does not violate the privacy of an individual employee to have a drug test be done upon pre-employment. About that pre-employment process to hiring employees could have cannabis, what changes you've even seen on case law specific?
Yeah, where I've seen it come up is in the issue of medicinal marijuana, where you have a physician's prescription to use it related to a medical condition. What the Supreme Court, the last time it was in front of the Supreme Court was a couple of years ago, and it involved this issue because an employee was given a conditional offer of employment, took a drug test, tested positive for cannabis, but then produced a medical marijuana that said he had a valid prescription to use it. Part of the argument was, well, if you have a medical condition, it is a disability, and the failure to hire that individual constituted disability discrimination because you need to make an accommodation. What the California Supreme Court, now this is prior to the recent amendment on this, but what the California Supreme Court said is marijuana is illegal under federal law. And the fact that you have an exception to have marijuana as a medicinal benefit or even as a prescription does not trump the employer's right to terminate for violations of criminal conduct under federal law. What I have not seen any further issues from the Supreme Court on this, but again, it takes a couple of years for these cases to get up there to get clarity on it. But that's the last interpretation of the statute and holding of the statute that I've seen.
David, what would you say is the best course of action if that happens now based upon the environment that we're in? If somebody says, hey, I went to the doctor, I'm now being prescribed medicinal marijuana, here's my medical marijuana card, it's being, whatever it might be. I know for certain different diseases, there's additional protection. So, we'll just say epilepsy to prevent those things. Here's my medical marijuana card. What's the best course of action for a business do you see?
Best course of action I see is to understand really what the issue is and compare that with what the requirements of the job mandate. Obviously, if the person is hired as a driver and has an additional marijuana card, that's probably not a good position for them to be with, or if they're dealing with power tools. If they're in an office, the standard would be how hard of a policy do you want to enforce? As a general rule, the question when it comes to disability, do you take an adverse employment action because of the disability, or do you take the adverse employment action because of the illegal conduct? And that's where the fight always is going to be. If a person needs their marijuana or their cannabis and they do it voluntarily, but they're doing it through a medical marijuana card simply for the sake that they want to do it as a quote usage, that's probably okay to terminate them. But for example, if epilepsy, if they've got a specific requirement that they can point to and say this is causing it, then you may want to investigate it further. And part of it would be contacting their physician and get a list as to really whether or not it's necessary, what types of restrictions are available, and make sure that if you've got a zero tolerance cannabis policy, you want to say we enforce the zero cannabis policy. If you light up during work, we are going to terminate you. If you come in under the influence, we will terminate you. If this is something you're going to do on your own away from the job, and it's necessary to your treatment of your medical condition, you may choose to be more forgiving. The medical marijuana, again, and prescription is not a free ticket because, again, federal law still states that it's illegal.
Mm-hmm. Yep. Excellent. Well, I know we're running a little bit low on time, but wanted to open up for some Q&A on anything question related to HR, different scenarios, things like that for anybody in the group. I have the chat in front of me, and so let me pull up this. And if there's no questions, then Deborah, I know you have a few things to talk about before our time is up for the hour. And so I'll leave it for a couple more minutes.
Okay. If anyone has any questions, you can put those in the chat box. If not today, then you could copy down the information that Tyler had on the screen, and I'll bring that up as well. What I will do is finish up the presentation. Just bear with me to share my screen here. Here we go. I know that this is how we started the meeting. And I'd just like to give a thank you and a shout out to our corporate members. Without you, we could not hold these type of meetings. Again, we have quite a few corporate members, and if anyone is interested in membership after this meeting, just send an email to the admin@dmasocal.org. And I know that we do have some information available about asset-based members. This is just an example of the benefits for asset-based members and also non-asset-based members. We have a lot of great programs for both. Our next big event is the golf tournament, which raises funds for scholarships and charities. And we had to move the date from May, obviously for obvious reasons, to October 9th. It will be at Los Serranos Country Club in Chino Hills, and we are all looking forward to getting out on the course and having a good time. There will be some new procedures in place, and we're still learning as we go along, but we will keep you posted. We do have a title sponsor so far, Casco, and thank you very much, Casco. After this seminar, we have another webinar in July. We're planning to go dark in August, although we may have a short get-together, like a happy hour for the group. And then an in-person social event in September, possibly. Again, the golf tournament. And then November, a networking event, possibly a speaker. And then we have our holiday celebration in December. Again, all locations and dates are subject to change. This is a slide about sponsorship opportunities. If you would like to sponsor a webinar like this one, we offer that for $650. And if you are interested, just go to our website or call us at the DMA office. Again, here are our two speakers, and I believe I have their information at the last slide. Here we go. So I want to thank everyone for being here today, and certainly reach out to David